May I, my lordships?
Yes.
I beg to mention item number 6. This matter will be listed tomorrow, my lordship.
Why?
Mr. Arich Navin he'll be appearing in this case.
May I, Lordship? Item number 6. Lordship, I on behalf of G. Lolen, Lordship. Lordship, he is unable to attend tomorrow, Lordship. The matter may be after vacation, Lordship.
That NIT.
NIT, Lordship.
Yes.
NIT is different matter, Lordship.
Huh?
NIT, Lordship. Land. NIT land.
Yes.
Yes, Lordship.
Not the tender.
Yes.
It's not a tender.
Yes, Lordship.
NIT method.
Yes, NIT matter.
National Institute of Technology.
Yes, Lordship.
Yes. So
Lordship, G. Lolen is the standing council of NIT, Lordship. He is also the affected person. Affected. So, Lordship,
who is affected?
NIT.
When?
After vacation, Lordship.
Okay. On the prayer.
Pleading completed, Lordship. Pleading completed, Lordship.
Why this has been listed for orders?
Lordship.
We have filed it.
Yes, Lordship, they have already filed.
R1 file affidavit.
Lordship, affidavit is filed if any record rejoinder is supposed to be filed, but he.
Anyway,
Rejoinder.
on the prayer of Mr. And on the prayer of as prayed by the learned council for the parties, list this matter after 3 weeks.
Much of it.
Lordship, my appeal is more on technical than Lordship, merit of the text, Lordship. May I take Lordship to the impugn order itself? It's the page 13, Lordship.
Just wait.
Page 13, Lordship.
Yes.
The relevant is at page 15, Lordship. I'm taking Lordship to the paragraph 3, Lordship.
Page
Page 15, Lordship.
15.
15, Lordship.
15.
15, Lordship.
Yes.
Paragraph 3, Lordship.
The
The basic ground of such challenge is that no memorandum of charges has been framed till the date against the petitioner, though the suspension order was issued in contemplations of a departmental proceeding, and therefore such prolonged suspension is not sustainable under law as declared by the Honorable Apex Court in case of Ajay Kumar Chaudhary versus Union of India and others so and so. The paragraph 4, Lordship. It is the further contention of the petitioner that though the period of suspension has been extended after purported review, however, such review is not supported by any reason, and the affidavit filed by the respondent authorities also do not disclose any reason for reviewing the order of suspension and extending the same, and therefore such exercise in derogations of law laid down by the Honorable Apex Court in Ajay Kumar Chaudhary. These are the Lordship, two Lordship basic issue which have been addressed in the present Lordship writ petition. Here Lordship will find the issue is Lordship the further continuations. The extension is not in terms of the rules. That's the issue which has been determined in the present case, Lordship. Accordingly, Lordship will find from the rest paragraph, these issues have been considered, whether the continuation is legal or illegal, Lordship. Now, ultimately, Lordship, kindly come to the operating portion is at page 18, paragraph 13. I'm not taking Lordship to the rest paragraph because rest paragraph, these two issues only have been considered, Lordship. In view of the following discussion, reasons, and decisions, the present writ petition stands allowed by setting aside the impugn order of suspension dated 29/10/2022. This is the initial suspension order, Lordship. The extension made which were made later, Lordship, that have not been even touched by the learned single bench.
So what's wrong?
Lordship, the extent continuation is held to be Lordship, illegal.
We'll modify that. This 29/10/2022, as well as the extension will set aside.
Lordship, what I'm submitting is Lordship, the earlier order, Lordship. When this writ petition was filed, Lordship, this 29,
You tell
10,
us
20.
what's wrong in the judgment.
Lordship, what I'm
You want that this extension should also be set aside.
No, what I'm submitting is Lordship. So far extension is concerned, Lordship. If that is held to be illegal, not in terms of the Lordship rules, then Lordship direction is given to reinstate the officer. That's all right, Lordship. What I'm submitting is Lordship, this initial suspension order, which is at the discretion of the authority, Lordship. They should not have been disturbed, Lordship. That's only my submission, Lordship.
So what benefit you will get?
Lordship, because Lordship, this is the foundation, Lordship. Because the investigation is still on, Lordship. Anything may, Lordship, come out, Lordship. So, if initial suspension order itself is, Lordship,
What do you mean by suspension?
Lordship.
What do you mean by suspension?
Suspension, Lordship, temporary, Lordship, is Lordship, restraint from working, Lordship.
You don't find any grounds to interfere.
Lordship, the issue is not, Lordship, whether legality of this very suspension order. The issue is of the continuation, whether continuation is,
Yes.
Lordship.
So we'll provide that just modify to the extent that including the modification or extension also goes.
Lordship, this suspension order, Lordship.
No, it appears that when we, if I correctly understood that the learned single judge only set aside the initial suspension.
Lordship.
You want that the extension should also be set aside.
Lordship, Lordship, the initial should not have been Lordship disturbed. That is my submission, Lordship. It amounts, Lordship, wiping out the entire, Lordship, the foundation, Lordship.
I'll just admit it, we'll see.
Lordship.
Otherwise, it was the initial suspension order was also under challenge. It was our categorical ground in the writ petition that these writ petitioners, all the private respondents 1 to 4, have never been given examination duties from the year 2015. The suspension order itself was totally illegal and arbitrary because I had no role. In fact, till now, the suspension was around 3-4 years back. Till now, no memorandum of charges have been issued, my lord. There is nothing criminal against me. Absolutely nothing.
We'll see.
Yes.
I'm not passing any interim. We'll just admit and post it for here. Okay. Heard Mr. Estafin, learned senior government advocate for the appellant, and Mr. Dipagi, learned constitutional. For respondent,
Lordship, I'm
Yes, I have put it.
it is respondent.
admit the appeal. As Mr. Dipagi enters, appeared on behalf of respondents,
Sole respondent.
sole respondent. The issuance of notice is waived. List for hearing in usual course.
Obliged. Same order up to 4. Obliged.
My lords, by the judgment and order of the learned single judge, the state has been directed to pay ex gratia compensation of 50 lakhs to the writ petitioner, my lord, who is the wife of a deceased IRBN constable, my lord. My lord, the issue here is only on the interpretation of the scheme, whether his case falls within the scheme or not. Our state's contention is that the writ petitioners husband's case does not fall within the scheme because the scheme is a welfare scheme, but it is a special welfare scheme, which emphasizes that the disease, the death, or the injury, serious injury has to be caused while performing duty. It is not only being on duty. Being on duty is a broader aspect.
Let us see the policy. Where is the policy?
Yes, policy, my lord, will find at page 275.
270.
275. May I read, my lord? Notification in the interest of public service and in supersession of the earlier government notifications issued notified by so and so, except as respect things are done or omitted to be done before supersession, the governor of Arunachal Pradesh is hereby pleased to adopt and notify a new scheme,
Close to
namely
A. The 24 hours from the globe. Yeah, so it includes the duties or disaster management. What do you say? From duty.
well,
Yes. Yes.
Yes, my lord. Today
Yes.
matter has come, yes, my lord. Today matter has come for consideration of the stay, my lord. And I don't think, my lord, there is any prima facie case, number one. Number two, my lord, balance of convenience also doesn't lie in favor of the government. And thirdly, my lord, they are not supposed to, my lord.
See, what does it say? What does it say? Who are killed, right?
My lord,
While performing law and order duties or disaster management.
right, my lord. So, my lord,
You are on
they are-
duty.
right, my lord.
After the duty, you are returning to your home.
My lord.
Can it be called while performing duty?
No,
Law
no,
and
my
order duty.
Number one, my lord, I am in round clock duty, number one. Number two, 24 hours duty. Number three, my lord, I have been directed or entrusted with a particular work, my lord, to collect the information. So unless and until I have returned after, yes, my lord, from FIR yesterday shows that I am on duty, number one. Number two, my lord, after collecting some information, unless and until I, my lord, report my commanding officer. the
Sir,
duty
we'll
continues.
examine.
My lord.
We'll examine.
My lord,
But
you
Mr.
will examine, and at the same time, my lord, Lordship may not
Where is-
interfere with the interim prayer for stay.
Till
They are not going to
disposal, we're staying the judgment and order.
My lord,
Because it's an interpretation and prima facie.
court has, my lord, learned single
may not,
judge has,
in your case, it may not apply. All right.
which one?
But
Notification.
Mr. and-
Notification is applicable. It was ultimately interpreted by the single judge by giving a lucid judgment. To what extent is applicable, to what extent it is not applicable. They never
Okay.
disputed the, my lord, stay, my lord, FIR. They did not dispute any question, my lord, regarding the, my lord,
Where's the
contents of the
FIR?
FIR.
Well, FIR will
FIR showed, my lord, they are on
find it.
duty. A report says, my lord, they are on, he was on duty.
Page 221.
221.
Yes, ma'am.
Now, what is the question, my lord, to say duty and distinction between duty and in performing duty? A person who is in duty, he shall be deemed to have performed the duty.
Said person most of was on duty at the time.
Now, second para, also kindly see the said person amongst
That copy
Dragon
will be
was on
at
duty.
222.
Rounding clock duty. Something.
Yes. The said personnel amongst Dragon was on duty at the time of the accident, and he had gone to cross-check the information that some miscreants from the staff were trying to enter through the Daran village into Arunachal Pradesh. There is no any, my lord, any iota of doubt that he was not on duty. Lordship has given on the other days, cited a question, my lord, an example. In the chamber, my lord, Lordship normally used to sign the, my lord, number of orders. Can it be said? Then when the court is not signing any order in the courtroom, therefore court is not is not on duty. Any
Okay,
judge signing
thank
any
you.
order,
Heard Mr. N. Ratan, London Additional Advocate General for the appellant, and also heard Mr. A.K. Prakash and Mr. M. Kato, London Council, London Council for the respondent,
Well, the time for the respondent number
And-
5, mother.
and Mr. M. Kato, London DSGI, for respondent,
5, respondent number 5.
respondent number 5. This intercourt appeal is directed against the judgment and order dated. Please. Where's the judgment?
Page 16 onwards, relevant,
Order dated
21/1/2025.
was by the learned single judge. Whereby the respondent the respondent has been respondent authority has been directly to grant ex gratia compensation of rupees 50 lakhs to the petitioners.
Yes, ma'am. Petitioners.
Within a month, no, it's okay. Petitioners, as per the, what is this policy?
Policy,
275
275, my lord.
in terms of the
6 November 2019.
611.
policy of the state. That is the notification dated 6/11/2019. Providing, for payment of ex gratia grant. No, as per the Arunachal Pradesh, in terms of the Arunachal Pradesh ex gratia grant within Brigade State Police, Fire and Emergency Services from our Indian Armed Forces and Forces and Central Armed Police Forces within Brigade State. Page President Brigade Close Policy 2019. Admit the petition, appeal admitted. The appeal admitted, no formal notice need be, as the respondents are duly represented, the formal notice is waived. Then, there is a IA.
Yes, ma'am.
In IA, same, so and so, so. Having considered the same, heard so and so, so and so, so. Having considered the submissions and the perusal of the so and so policy, same policy, huh? We prima facie found that although the petitioner was engaged on duty round the clock, he was returning after the duty. Therefore, it prima facie may not. No, therefore, it may not be considered that he was killed while performing law and order duties or disaster management, till proposal of the appeal, the implement judgment and order that is so and so shall remain state.
Highly operational.
20 July.
Okay, kindly record my submission, my lord.
I had disposed.
Kindly
We're
record my
staying
submission.
for a, yes,
20 July. 20 July.
Next, my lord, Lordship has fixed the date, my lord.
huh?
Or Lordship has fixed the matter, my lord, for hearing. Or the Lordship is going to fix the matter for
We
hearing.
have admit already so and so, you list for hearing in the usual course.
20 July.
Next, my lord, next, on 20th July, my lord. It is, we have our urgency, my lord. Man is suffering for since long, my lord.
Yes,
No,
when do you want?
20 July.
28th July?
20.
28.
28 or
No,
20?
At next, my lord, any date in the month of August.
28.
Yes, yes. List.
It's 28th July on Monday. It's Monday, 20th
28.
July.
So make it Tuesday.
No, on 20, they'll be coming here. They'll be appearing here. Physically.
Ask, request him to appear on Tuesday.
No, in 28, there is another matter also is fixed.
Hmm?
That is why. There is
Let
another
him-
matter also is fixed.
Let him stay back for a night. Enjoy the cool breeze of Itanagar in Naharlagun. 29. 29.
Obliged.
What is it, IA?
Lordship, this is an IA filed by the writ appellant uh, under section 5 of
108.
Limitation Act seeking condonation of delay of 114 days in filing the writ appeal.
14 days or 18 days?
100.
Any objection? No objection.
No objection.
Heard, Mr.
B. Kamdak.
So it's learned counsel for the applicant. And Mr. M. Kato, learned DSGI or
All respondents
for
all opposite parties.
opposite parties, public respondents. This is an application of Limitation, Indian Limitation Act 1963, praying for condonation of delay of 118 days in filing the connected writ petition. Mr. Connection, writ appeal. connected writ appeal, huh? Here, they already. Before it is. This is. Having considered the grounds put forward in this application and the prayer not being objected to by the learned counsel, but objected to by the respondents. We're satisfied that sufficient cause is shown which prevent the appellant to file collected appeal on time. Limitation. Accordingly, we deem it appropriate to allow this application as the delay of 118 days in filing the collected appeal is conducted. I stand allowed and disposed.
Deeply obliged.
Your Lordship, if Your Lordship fix this matter tomorrow, Your Lordship,
Why?
this matter, the entire brief is with my friend Theatre, who is due to some medical emergency, could not come to the court today, Your Lordship. Your Lordship, fix this matter tomorrow, Your Lordship.
Some other day,
Thursday
not tomorrow, some other day.
or some other day.
Can it be on next week?
Next week. Okay. On the ground that Mr. T. Learned additional PP who has been entrusted with the this matter has got medical emergency. Come on, MS. T. Learned additional PP. Press for a short accommodation. They are not been objected to by learned senior counsel, Mr. A. Upon Amicus.
Yes.
Amicus and Mr.
I'm amicus too.
What?
For the victim. For the victim, Your Lordship.
Okay. And Mr. Thiessen, learned Amicus for the list this matter after a week. After a week.
Complaining.
Sir, after a week.
Yes.
Yes.
In fact, Your Lordship, if I correctly remember, the complainant was to be called for. So notice was issued. I do not know whether that has come back or not. Complainant.
He is there.
Yes, sir.
You are there.
Or
He's for the informant.
complainant.
Yes.
If it's for complainant, that's okay. Anyway, it's
You are for informant or the complainant.
No, I'm for the.
being accused.
Okay.
I mean, victim.
Ah.
Victim.
Ah.
Order dated 225 may be seen.
Hmm.
Since service of respondent number 3 could not be ascertained, respondent number 3 was
Respondent number 3, yes?
as
Is
respondent-
appearing respondent number 3? You have the paper book. He's for the respondent number 3. Yes.
Lordship, before, I would like to apprise the paperwork which the registry has been furnished. It is not in sequential order, Your Lordship. 313, that has been. It starts from page number 45 and then it's backward, Your Lordship. 45, 44, 43, 42, 41.
Hmm.
And even deposition of the IO also. That has not been, it is not sequence. Again, deposition of the victim. So may I pray that registry may be directed to.
Otherwise, the statements are here.
Statements are
Only
here,
that is
yeah.
not-
Yes, Your Lordship.
They have to again change it. Make it fresh. Which page numbers you are saying?
Page number 45, Your Lordship, 313 of the accused.
313, otherwise starts
It's,
from.
it starts from 45. The starting page is at 45 and then 44, 43, 42, 41, 40.
Yes. Yes, Miss Enanju, learned legal aid counsel. Submits that the paper book provided to her is not in order as the paginations and the documents are not in order. What about you? Yours is okay.
No, Your Lordship.
Okay.
Same, Your Lordship. Even the statement of the
Yeah.
victim.
Having found that the registry is directed to prepare a paper book, proper paper book in order, and thereafter to furnish all the learned counsels list after 2 weeks.
After 2 weeks. Obliged.
I beg to mention items 10 and 11.
10 and 11.
This matter will be listed tomorrow.
Huh?
This matter will be listed tomorrow.
Why?
In this, Mr. Aris Navam will be attending. He has some difficulties. I have taken consent of that petition.
We'll list after 4 weeks.
No, but just now I got the information.
What is the matter?
Actually, this is relating to a tender matter. Relating to PDS contractor. So the last order says that government should only bring the instruction records. Records was brought in.
Next week, after a week.
No, there is urgency. There is a interim order operating.
We'll see. After a week, next week.
Tomorrow.
Huh?
Tomorrow.
It's not your convenient only. Look at us also.
Okay.
Monday?
Fine, Malad.
Monday. On the prayer of Mr. MS K. Wangmo, learned state council, on the ground that Mr. Aris Navam, learned addition advocate general, has some personal difficulty today. List this matter after a week.
On Monday.
After a week, on so and so. You just keep that. Yes.
Item number 1, my lordship.
What?
I have taken consent from the petition. This matter will be listed after a week.
What is the matter?
Land matter.
Consent. You have taken the consent. On the consent of learned counsel for the petitioner, MS so and so, learned counsel, learned state council, press for listing of the matter after 2 weeks. Prayer allowed, list after 2 weeks.
My lord, I beg to mention item number 25, my lord.
25.
My lord, this matter may be listed next Tuesday, my lord. Next Tuesday, my lord. Next week, on Tuesday.
Why?
My lord.
25.
Yes, my lord.
Yes. Any objection?
Next Tuesday, my lord.
What is the matter?
This is regarding salary, my lord.
Huh?
Salary, my lord. Salary.
Salary.
Allowed.
Okay. As agreed to by the Land Council for the parties. Listed. LLNOC for the petitioner and MS T1 London State Council. Come on, list this matter
Tuesday, Monday.
On Tuesday, next week.
after a week on not Tuesday, Wednesday, make it Wednesday. That's
Obliged, madam.
Lordship, I would like to mention item number 8, Your Lordship.
hmm.
Yeah, you have to file affidavit, Your Lordship. Some time may be given, Your Lordship.
8
8,
affidavit,
Your Lordship.
on the prayer of on the prayer of Ms. Arbasar London State Council. List this matter after 3 weeks so as to enable her to file response. Yes.
Lordship, one more item number 24, Your Lordship. I'm mentioning on behalf of G. Atta, Your Lordship. She is not well today, Your Lordship. Can this matter be taken on Monday, Your Lordship?
On
Monday.
We cannot fix all the matters.
But the government, they are supposed
What
to
is
file
the-
a report.
What is
But
what is the matter?
No, this is regarding the eviction in and around airport.
Okay.
The Lordship was pleased to direct.
Not
the-
before the bench. Do your writ petition will be dismissed. Try on some other bench.
But basically,
when-
it's on the question of principles of equity. Why only me? And on that basis, Your Lordship had directed the Deputy Commissioner
Sir,
to file a report.
You know, there is no concept of negative equality.
But then
And
the-
according
There
to
are-
under Article 14 is always a positive one.
that
There
is
is no concept of negative equality.
But then
Yes, you want to
Very-
dismiss the writ petition.
Verification report we have received, Lordship,
On
on
So-
Monday, Your Lordship.
So when do you want?
not anytime.
On
But
Monday.
only one thing is, since they have made a report,
Hmm.
the report should also be made available to me so that I can.
You
at least-
furnish.
Yes, Lordship. We have received the verification
We have
report.
directed to have a
Yes, we have
verification.
received it.
Yes.
You furnish?
Lordship.
Land Council to the petitioner and MS Arbasar London State Council for the respondents, as directed by this court. No, MS Basar London State Council submits that she has received the verification report as which has been caused as per the direction of this court. As per the direction of this court, therefore, praise that. Are you want to bring on record?
That can be.
You want to bring on record?
I think that would be better by filing an additional affidavit, small one.
Yes, Lordship, we can do that.
Which she would like to bring on record by way of affidavit. Have been considered the submission, Ms. So-and-so, is directed to bring on record the verification which she has received. Verification report. I
Yes,
think.
verification.
Report which she has received by way of affidavit within a week. Within a week.
On Monday, Your Lordship.
List the
No, within the
matter.
week.
List the matter. Not necessarily Monday. Let us.
But
Thursday.
let it be after break so that copy will be given to me. Then I'll make my.
We'll allow your writ petition. Don't worry. Anyway, then
After a week, Your Lordship.
after a week, if you want to, there's no hard and fast. There's no interim order.
No, there's no.
It would be more serious in view of the present scenario about the aviation.
In that case, Pasigar has to be shifted.
No, it is
That
possible.
was a wrong choice by the.
Okay.
Anyway, my lord, we'll take it after.
After the vacation.
After a week, after a week.
We'll see after a week.
My lord, may I mention item number 15?
Hmm.
Item number 15, my lord, respondent 3, 4, and 5 has filed their affidavit.
Hmm.
1 and 2 has not filed.
Hmm.
And my lord, I may be given some time to file my reply also to.
Okay. On the prayer of Mr. T13 London Council for the petitioners, list this matter after three so as to enable him to file affidavit in reply. To the affidavit in the opposition filed by the respondent number
3, 4, and 5.
3, 4, and 5.
4 and 5 is NSPC.
Huh?
4 and 5 is NSPC.
Published.
My lord, beg to mention item 17
7. Yes.
on behalf of N. Tajay.
Huh?
I'm on behalf of N. Tajay, petitioner for counsel for petitioner.
I think this is with item 6.
17.
17.
Yes.
Yes. What do you want?
Leading counsel is in medical emergency.
This is listed for orders.
Yes, ma'am. We have filed our affidavit, my lord.
You have filed?
Yes, madam.
Okay. I think for that only it has been listed. For filing of affidavit only this has been.
Yes, madam.
Okay. On the ground that leading counsel Mr. N. Tajay has some personal difficulty, Mr. So-and-so, London Council appearing on his behalf, pressed for and granted 3 weeks time to file affidavit in reply.
Yes, madam.
Okay.
But my lord, I beg to mention item number 21
21.
on the behalf of Etatak.
No, this is with item 20.
Yes, my lord, I have taken consent from all the parties, my lord.
Item 20 also.
Yes, my
Item
lord,
20.
and I will file rejoinders after convictions.
On the prayer of Mr. So-and-so, London Council for the petitioner, London Council appearing on the 8th of London Council for the petitioner in writ petition 6TQ of 2023, that this matter be listed after 3 weeks, so as to enable the petitioner to file their file their affidavit in reply.
May I please, my lord? My lord, my presence may be recorded. I am for the sole respondent in both the writ petition. Private respondent.
So-and-so, huh? Is
Obligement.
So-and-so, huh? Is present for responding. Is present, huh?
May I, Lordship?
Yes.
Lordship, with the consent of opposite party, I beg to mention item number 3, Lordship.
Item?
3, Lordship.
20.
3, single 3, Lordship.
Item 3?
Yes, Lordship.
Yes.
Lordship, I'm appearing on behalf of Senior Standing Counsel, Tavatagam, Department of Education, Lordship.
Yes. On the prayer of so-and-so, London Council, appearing on behalf of Mr. T. Thagum, London
Lordship,
Council,
matter fixed
Standing
after few
Council
weeks.
for Education Department, and the prayer not being objected to by London Council for the is this matter after 3 weeks. MS so-and-so, London State Council is present.
One more item, Lordship. Lordship, 19.
Same word. Yes.
Obliged, Lordship.
Right.
This is when cancellation of government's appointment case. Till that they have not filed their affidavit. I am on a stay.
We have communicated several times, my lordship.
So,
Still no instruction. Instruction not coming. I can see there are 2 letters from Joint Secretary and also this thing.
Ground was that I have shifted to another village, which is incorrect. If issues so could have explained it, because the whole village has shifted to our own land because of the some miscreants cut off the hanging bridge. So we as a whole village has shifted to our own land, at the other side of the river. I have not changed village.
What is the infune order?
At page 40, my lord.
Yeah.
This is incorrect. If the notice was given, I could have clarified. Yes, he has migrated to another village, Tadogitu, in Tato Circle.
Yes, so you have not shifted.
Oh, I have not shifted.
It's still the same village.
Yes, the same whole village has shifted. The whole village.
Not you only.
Not me.
There is no village
No.
in the earlier location.
Because the suspension bridge was damaged by miscreants during some protest.
Yes.
And there is a provision for following natural justice in their own guidelines. That is the only thing.
No instructions. We have communicated several times.
It's okay. Communication is something different. You have not received the communication. What will dispose of the matter?
If it is in the same village, this can be disposed of. But I'm not sure whether this thing don't do.
What is the guideline? This provides for
page 18. Relevant is at page 26.
This is a guideline.
Yes. This is the guideline I'm told is now in force. This was placed before this honorable court.
Page
26. It starts at page 18, page 26. Dismissal of 8 GBs, D8D. Principles of natural justice will be followed.
Dismissal of it's a termination or what? What do you call it?
He said abstain. I don't know what exactly this is.
Termination is such.
Yeah, appears so.
Shall not use the
Dismissal,
red food provided to him by the district and must reflect
the same thing the amounting to dismissal only.
We cannot say that it's a misconduct also.
My lord?
It cannot be termination.
I don't know. They would have filed an affidavit.
Divested of powers only.
What is this, my lord? If they had filed
We may be
affidavit,
given last chance.
they could have clarified.
We may be given last chance for that. Last chance. I will try to contact them.
What is there? What improvement you will bring?
Let's see. We haven't got any instruction yet. Something instruction may come also. Maybe because of this new district, DC has been changing there. Maybe because of that. You mean this new one, no? New.
Yes, you.
Yeah, because of that only this thing.
It's all given in the petition, sir. Whether new district, old district, it doesn't make a difference.
Because DC normally new one.
The reason is that you are alleging that the petitioner has migrated. What they are saying is he has not migrated because of the, what do we call it?
The suspension
Yes, now we don't know the fact also. We do not know the fact. Which one is real? The allegation is that he has already shifted from Tatu to the new village. So we have to get the report, at least instruction.
Where is the power to, issue type of order?
Actually, power is
the Gambura can be dismissed.
Yes.
For misconduct.
Yes. But this is not there.
It's basically a dismissal. He says, I should not even wear the red coat also.
Yeah. Would like to have in summer. Summer heat. Yes.
Last chance.
Stage in operating.
Yes.
Yeah,
Okay.
continue.
Mr. Defying learned counsel for the petitioner. On the prayer of Mr. N. London Senior Government Advocate, list this matter after 3 weeks for filing to obtain instruction. Obtain instruction as a last such. List after 3 weeks.
Interim order.
Interim order plus earlier shall continue.
Okay.
Yes, what is the matter?
Gas petition. Gas. Career option scheme.
Who is supposed to file additional affidavit?
Lordship will not file since affidavit in opposition is sufficient.
It's complete. Yes.
Sir, they have given me they have not given me retrospect order. Retrospect order. They have given 23, but they have to give me 18 according to Rule 2016.
Sir, what do you want?
Basically, they have to give me order 2016 under rule.
What is the order? Where is the minutes?
Minutes are this. Minutes are enclosed.
Which
Yes.
minutes or which order you are challenging, sir?
Order is enclosed. On page number 179.
You have been promoted.
Yes.
You want a retrospective promotion.
Yes. Not no.
What about this career
Yes.
advancement scheme is for whom? Is
Two-
for whom?
2016 rule. They have to give me according to rule 2016.
What is 2016 rules? Your basis is 2016 regulation.
Yeah, sir.
Yeah, where it is?
May I read, sir? Rule 2016 says that qualification for appointments of
Sir, where it is? Which page? Which page?
Annexure number 7,
Page number
187.
187.
Yes, sir.
There is no 187 page. Affidavit.
Affidavit.
$187. Yes.
Qualification for appointment of teachers and other academic staff.
Promotion
in
under career
college other layers of grants of and guides may be given to them either for appointment of to rule number 10 and R 2018. There are two rules. This option can be exercised up to 31st December 2003, and the date of eligibility shall be retained as the date of promotion on the date of submission of application, and candidate should fulfill the eligibility criteria.
Yes. Have you opted for have you been given any option?
Yeah.
Or have you opted for?
Yes, 2016. Yes, I have opted.
Opted?
Yes, sir.
Where it is? From where we can say that you have given the option and you,
Sir, I have
you
applied
opted for it.
I've applied for the form 2016.
Where it is?
I should not.
Sir, it's very difficult. Can you not engage a lawyer?
But two years I passed. He did not do anything. He did not do anything. He did not do anything. 2 years I passed.
It's very difficult.
Yes.
You are a professor.
Yeah, yes.
Can you not engage a lawyer?
Sir, I have engaged a lawyer, but he did not do anything.
No, it's not a question of not doing anything. There's a procedure. Process is there, procedure is there. Just cannot be heard and decide the matter like this. Well, understand, right? You have to properly establish your case. Yes.
Lordship, presently he's serving as a professor in the Department of Education in Rajiv Gandhi University. And he joined in our university during year 2015. 2015.
As
And
an associate professor.
associate professor.
Yes.
Then Lordship, what happened after joining 2015, during 2018, as per the UGC 2018 and 16 guidelines, seeking for retrospective promotion.
Yes.
But whereas 2018, though his service length was qualified, but as per the screening committee report, his application was incomplete. So his application was rejected in the past application of 2019. Then what happened again? He applied during 2021. During 2021, what happened? Lordship, again he filed an application form as per the prescribed norms of 2018. Then what happened? Application was considered and exam was conducted. Interview was conducted within the university level. Screening committee, two outsiders, expert from the two outsiders. During the interview, he was disqualified. He was disqualified at the screening board, not to be promoted as a professor, because as per the report of the screening committee, he was not qualified, even the minimum marks. So what happened? Then he filed the representation, and again, Lordship, what happened? In 2021, we served a letter to him to file in another application in future. We'll consider his case. Again, during 2023, he faced the interview again, and his case was considered and through executive council. And now he is serving as a professor. So now he's claiming is that only he should be retrospectively, he should be appointed, claiming for retrospective salary of 2018. And also he was not qualified. He could not qualify the minimum, the criteria of the UGC norms.
Could you page 187? 6.3. Right side.
Lordship. Affidavit.
Yes. Page 187. This is your documents.
Page 87. My is not 87 is there. Yes, Lordship, yes, coming. Page 87. Page 87.
187.
187.
Starting from 186.
Mine is 87 only.
187.
कौन सा है इधर
नहीं
मैं देख सकता हूँ
On which date you were promoted?
Ten 18 को 16 को
ना qualification performance of the teacher.
16 का कैसा 18 का कुछ
Lordship, here, see the how it's rejected.
When you were promoted?
Pardon, sir?
When you were promoted?
I was promoted to 23 February. Have read it to 2023.
23.
So 23.
With this regulation came into force?
Yes, sir.
Huh?
Two regulations are there, sir.
It's in 31st July.
Yes.
You are already promoted.
Yes, sir.
Next number, page number
This regulation will apply
yeah.
for the persons who have not been promoted.
Yes, yes, sir. They have given me permission to apply.
This will come into effect 31st July 2023. You were already promoted.
Promoted, yes, sir.
So, how this regulation will apply?
2016 May, we can apply.
But consider when whatever may be the reason you could not be promoted. It's not a case of you have not been considered.
Sir, ये route में लिखा है.
It has been see, this rule will not apply because you have already promoted before coming into force of this amendment.
Yeah.
Right?
Yes, yes, sir.
The 6.3 which you are relying, right? This will come into effect from 31st July 2020.
Yeah, yeah.
You are already promoted by that time.
Yes. Listen, what they have given me, they have given me a promotion from 2000, not given a promotion to 2016, because they have given me,
Now, how you are claiming on the basis of this rule?
because they have given 2006, sir.
Sir, you read the rule, page 186, when it was notified.
Yes, sir. On page number
This
2.
is regulation may be called the university so and so. Third amendment regulates 2023.
Yeah, yeah.
Publish notify on 31st July 2023.
Yeah.
You are already promoted by then.
Yeah.
So how this rule will apply? This is for, you see, 183, you read the criteria for promotion under the career advancement scheme.
Yes, sir. Yes, sir.
When you are not are you claiming further promotion?
Sir,
From the post of professor.
Sir, there are two rules after 2016 and 2018.
So are the 2016 then. So are the 2016. Why you are referring to this? 2018 amendment 2020. Why you are relying this?
But I apply under 2016.
Where is the 2016, sir?
Sir, please see the page number 190.
Huh?
190. Page
190.
number- May I read, sir?
Yes.
Criteria for promotion. The criteria for promotion under career advancement scheme and loan under the regulation effective from date of publication of the regulation. However, to avoid the hardship of the faculty members who have been already applied or are likely to apply December 2024 as per the UGC regulation, minimum qualification of the parent of the appointment of teachers and teacher university and college and many other maintenance standards are.
This will come. This will be effective from which? From the date of notification,
Yeah.
6th June 2024.
Yeah.
Right?
Yeah.
However, to avoid hardship, so and so are likely to qualify till 31st June as per the UGC guideline minimum so and so. Choice may be given to them either for being considered promotion under 2018 rule. The date of the release will be retained as the date of promotion. The date of submission of the application, the candidates will fulfill all eligible criteria. No, this also you, by that time, you have already promoted.
Yes, sir. No doubt, sir. They have promoted. They didn't give me a retrospect order. Retrospect order.
What is the right?
Yes, sir. It has been written here.
So this will apply to those who have not been promoted already.
No, sir. But they have given me under a 2016 rule. They have.
However, to avoid hardship to those faculty members who have already qualified or are likely to qualify. This will apply to those persons who have not been promoted.
But sir, when I applied for the post of professor under route 2016, because they have given me order, they permitted to be.
Where is 2016 rule?
Yes,
regulation.
Yes, sir.
Oops.
This one, sir. Page number 179. Page number 179. Sir,
Request for permission.
with reference to your letter number, dated site number, I am directed to inform you to complaint 30 permitted to apply in a fresh UC 2006 16 clear route comes up to apply fresh format for UC regulation 2016 for position under case 13 to 14. They given me order.
With reference to letter so and so, I am directed to inform that competent authority permitted you to apply in press format as per UGC regulation to say for permission CS from level 3 and assistant professor level 4 professor. This you have been considered and you
Yes, yes.
They have not considered me. They have not given me retrospect according to
This is the order 23,
route 2016 के मुताबिक they have given me order.
Sir, difficult.
Sir, they have given me order. You have applied.
That's why you have been promoted by now.
According to 2016, all the teachers were given promoted. All the teachers were promoted.
Petition and in person.
Yes. 2006.
Nabam.
Yes.
Learned
Standing council for RG.
Standing council for RGU for the respondents. Admit the petition. List for hearing after 3 weeks. 2 weeks. You prepare if you want to argue the matter, you prepare yourself. All right. And if not, I would suggest you to, if you can engage, you are a professional, you can engage a lawyer, help of the lawyer. All right. We'll see. Yes.
This matter of service is completed and it's ready for hearing. But before we go for hearing, the government has written so many things, and I would pray that government be directed to the records where from they have made those involvements.
What is the impugned order of the deputy commissioner? 58. Page 58.
Yes.
Yes.
Earlier settlement that the mutual mediation of Hong Village is foreign country is illegal, seem to violate settlement agreement, so he may apply.
58. Yes, 58.
This is on what basis he has passed, in what capacity?
Question here. In fact, he did not have authority to pass this order. The complaint was for cancellation of LPC, land possession certificate. So far land cancellation is concerned, it is the deputy commissioner who is the competent authority.
That has been cancelled in your favor.
Yes, that has been cancelled.
So you are
But-
agreed by
The other part,
decision number 1 and 2.
Yes, yes.
Why the tarikot will be distributed among the clan members of Loru? Fine of Mithun is imposed on so and so, Buloraki, for violating settlement agreement as per treaty. You are not Buloraki. Are you Buloraki?
No.
Who are you?
Buloraki is the one who obtained LPC.
You're Bulotado.
Yes.
So how you can agree by decision number 2?
Decision number 2.
A fine of Mithun is imposed on so and so. Has been obtained fraudulently without observation obtained NSC from village with hence decided male body so and Sri Bulodaki is hereby withdrawn and treated as cancelled. See, if this is the tariko should be distributed among the clan members
Equally. So this should not be here. In Lora, there are 3 clans, but other Loras, they were not party to this.
Sir, how do we decide that now? In
That's
the
well.
read proceedings.
Yeah, that's well.
How do you decide who is entitled, who is not?
No. We are not specifically saying that who is entitled or not entitled. But the order itself is wrong because there is no evidence from our side
that it is pertinent to mention that despite being qualified in PST-PET documents scrutiny on 9/6/2023, now your good office refused to issue appointment letter to the undersigned on trivial ground of not affixing a seal in Form 2, which is no fault on my part. Be that as it may, my only contention is that had it been the criteria for rejection of candidature, my candidature would be rejected during scrutiny on 9/6/2023 instead of listing in the accepted and qualified list. So that happened when this order at page number 42 came to be issued, which we have impugned, my lord. So, my lord, this is why we are prejudiced. My law is well settled in Vasis Narayan Kumar, 2024 SSC online, my lord. There, for trivial mistake, this gentleman also applied for the police constable, but there was a typographical mistake in his name. But for that, he was punished. His candidate sought to be rejected, and then the petition was allowed, my lord. And then, my lord, kindly,
what is the requirement?
Requirement is Form 2, my lord.
What is the Form 2?
Form 2 is at page 22, my lord.
Form 1,
Oh,
2,
sorry,
3,
sorry,
4.
but that, 1 second, my lord. I took out the affidavit in opposition of respondent number 3, my lord. Well, I think we have not put in the form number 2. Take care. Which page it is? Either one says page 6. Page 6. Well, in my read petition, page 6, my lord.
Huh?
My page 6 name. That's why I was correct in pointing out that. Page 6 of the affidavit in opposition by R3, my lord.
R3. R3 and 4.
Yes.
Ah.
There, my lord, will kindly come to page 6.
Yes.
Here, my lord, the signature of the secretary is there, except seal was not there, my lord.
No, no. Where it is? Page 6.
Page 6 of the affidavit in opposition by R3, my lord.
R3 or 4?
3, my lord.
This is R3 and 4.
R3.
R3 and 4.
R3.
Oh.
My lord, will kindly come to page 6. Annexure 1 series. In the bottom, my lord has seen that place and date, and the right, my lord, will see the signature, name, designation, Arunachal Karam Association, Itanagar. My lord, the mistake is seal was not put in, my lord. And my lord, this was corrected further in my. No, this was corrected further
after rejection.
Yes, my lord. The secretary who has said that I have forgotten to put in the seal, my lord. The signature, everything is genuine, my lord. In the rejoinder, my lord, I have put in the last page, my lord, 5, para 5, page 5, my lord. The certificate has been issued. No, it's fine. This is okay. Well, in my rejoinder, my lord, page 5, my lord. Annexure, only one annexure is there. This is to whom it may concern, dated 4 January 2024, my lord. This is confirmed that I have signed form 2 certificate.
Your form was of 2017. In 2024,
Yes.
you are obtaining.
My lord, what happens is they sign it, signs it, then thereafter all the sports person, discipline wise, my lord. For discipline wise, they signs it.
This item number?
6, my lord.
6 and 7.
6.
7 is what? 7 is rejection of same ground.
The sports certificate.
Huh?
Basis of the sports certificate submitted by the petitioner. My case is quite different.
What is the ground of rejection?
I think that the discipline which they have participated is not recognized by the state.
Okay. So,
my lord, kindly.
Form, you have submitted the form in 2017, having this certificate confirmed in 2024.
I agree, my lord.
7 years.
Without.
By that time, things.
But then, my lord, person has generally applied, except for this, my lord. And then in my rejoinder, my lord, the person who has issued and signed the form 2 has given a certificate saying that this form has genuinely been signed and issued by me, my lord.
In 2024.
Yes, my lord. Because they maintain serial number. My lord. Suppose, my lord, what happens is for football, there is another discipline. For cricket, another, karate, boxing, and all those things, they maintain it.
Well, direct this person to file the affidavit. You're the
In this, kindly see, in the bottom, that I am great thankful to my youngers who are assisting me. Well, that down below in the form, although it is signed, this certificate will be valid only when signed personally by the Secretary of the State Association. Seal is not mandatory. Even in the advertisement also, it says. Annexure 1 by the R3, my lord, kindly see in the bottom. Yeah, correct. Advertisement also they have said so. My lord, kindly, trivial mistake, this boy should not be punished to that extent, my lord. After all, he's a genuine sports person.
Yes. Yes.
My lord, in our affidavit, only because of the seal, absence of the
I
seal.
think it doesn't require, it's only sign. First sign. Once it is personal sign, seal doesn't make any difference.
My lord, yes, my lord.
Normally it should be. Certificate should be contains some seal and stamp.
Correct.
But then your
The
representatives
format-
will have to see the literally.
Yes. The format says,
Signed by the, personally signed.
my format provides for seal also.
Where it is?
My lord will find
The page 6 of his,
format.
page 6 of the,
Let us see the format.
page 6, my lord, kindly come. Page 6 of the R3 affidavit.
my lord will R3 affidavit, my lord. That is
6.
No, page 22.
Seal is also required.
Seal is there, my lord.
No, my lord, whatever they have, no, R3 kindly see,
R3, page 22.
This is, I don't, mine is written as page 6.
Page 6.
Mine is, kindly see, my lord.
This certificate will be valid only when signed personally by the Secretary of the State Association.
Yes, that is there.
But do you provide a requirement of putting a seal here?
My lord, in the original copy also, this is your copy page.
No, the seal is, it's here, blank. Page 6 only.
My lord, kindly come bottom, my lord. There is a.
Page 6 only.
Correct, my lord.
Yes.
My lord, kindly come to bottom.
Yes, this certificate will be valid only when signed personally by the Secretary of the State Association.
Signed.
Yes, we agree.
The first part we have complied.
What he's saying that the seal is required
seal has
because
not been-
the
correct,
form
I-
form provides for seal.
My lord, I am not quarreling on this. Only this is a trivial mistake. A person has come.
Yes.
At least this boy, my lord, at least.
My lord, I'll leave it up to your lordship, my lord, but they have the petitioner has to,
Judgment.
as per the advertisement, he has to face, the physical test.
I will face it. I will face.
That for a single candidate, whether that can be done, my lord. Only that.
Post is still vacant.
Have you crossed the, I mean, have you qualified in the physical?
No, that was not allowed.
This was when the
Physical
documents
test was,
scrutiny, it was rejected
Scrutiny, I was
during the scrutiny.
during scrutiny, my lord, both. Physical.
Have you cleared the physical test?
That in my no, my lord, in my representation, I
allowed.
have written so.
Not allowed. Because this application was rejected.
No, kindly come to my this thing. My
He was not
lecture.
Not allowed to participate in the physical test.
I was not allowed to participate, but
Therefore, there's no question of qualifying. I mean,
I'll face physical test, no worries, no. Kindly not punish this boy, man, at least, no, for a trivial mistake. And I'm not relying on the judgment also.
Just give the judgment.
But is that judgment we have printed out? On the same issue, no.
Why you are not relying on judgment which supports you?
You have not brought it. But I'll pass on. They have not brought the printout copy. 2024 SSC on 2024 SSC online.
There are so many SCC online.
Page 2, madam. I'll furnish this. Paragraphs are indicated.
Name of the party.
Versus Narayan Kumar versus State of Bihar and others on the similar facts. I read this 2 paragraphs for the facts. Versus hails from a small village named Deodar in Bihar. He belongs to the downtrodden segment of the society. He aspired to become a police constable and had applied for the said post under the reserve category, having possessed the eligibility criteria of being an intermediate 10+2 pass. He also cleared the written examination and physical eligibility test. Here, my lord, respectfully, I have.
Just give the judgment.
Yes, I'll pass on.
Next, item 7.
Item 7, my senior SMO was supposed to appear. However, due to his ill health condition, here at throwing now.
No, what is the ground? The certificate is not, I mean, this is not a sports which is recognized.
No, my lord, in similar certificates, other candidate has been made qualified.
They've been appointed?
Yes, for that I have already filed my affidavit.
What do you say?
No, but these petitioners, they belong, their certificates are not recognized. It is not recognized as guidelines, my lord. These are not state or school, state or national, my lord, or international. These are invitation games where they have obtained certificates on invitation. It's not recognized.
But in many occasions,
there was an interim order not to finalize. It has been finalized.
Well, there was an interim not to finalize. Thereafter, the number of candidates, the number of vacancy, and the number of candidates who qualified, it was less. Even calculating the number of petitioners, it was modified. Therefore, and those who qualified, they were.
36
there was an
posts have been kept for the petitioners in case after.
Where's the rejection? I mean, how do we know that Yours is which category?
My lord, I am a karate
Rejection
player
claim. Yes, then?
from various categories, discipline. My lord.
Huh?
Taekwondo, judo, Wadokai, Shitokan,
Huh.
and boxing also.
How many persons are here?
36 petitioners. Sir.
36 petitioners.
Yes, sir. And in some cases, the person who has possessed this certificate has been appointed as a constable also. That I have already filed my affidavit, bringing the record, all the documents where they have appointed.
Those who have been appointed, they possess similar certificates what the petitioners are relying on. They also possess other certificates which are recognized.
No, my lord, I have recently filed one rejoinder in their affidavit, opposition in affidavit.
There are those who have.
There are two candidates possess the same certificates, but they have appointed in the year 2017. Although their advertisement is different, but posts are same.
They possess.
No, my lord.
Any certificates, those who have been, some certificates are similar to the petitioners. They also possess other certificates which are recognized. That is the difference.
My lord, the record has no RTI. But the two candidates, two constables, they have same certificates. There are no any other certificates that they have produced and submitted.
What is the requirement of that certificate?
My lord, as per the guidelines, my lord.
What it is?
My lord, in our affidavit, my lord.
320.
Affidavit filed on dated 8/9/2020.
3 and 4.
3 and 4.
3 and 4.
Yes, my lord.
Respondent number 3 and 4.
Yes, madam.
Yes. Where is the guideline?
It starts at page 11, madam.
Appointment of marriages. C and D posting. What did the government of also say to?
Then at page 14, this is an extension of the earlier, this was the initial.
What is the requirement of those certificates?
Yes, sir. Eligibility, sportsmen who have represented, my lord, at page 14, if my lord will see.
Represented the state
Appointments under these orders can be made of a sportsman considered meritorious with reference to the following criteria. Sportsmen who have represented state or a country in the national or international competition in any of the games mentioned in the list, so and so. Sportsmen, then the second one will be sportsmen who have represented the university or inter-university tournaments conducted by inter-university sports board in any of the sports and so and so. Then third, sportsmen who have represented the state school teams in national sports games for schools conducted by All India School Games Federation in any of the games sports shown in annexure so and so. Sportsmen who have been awarded national awards in physical efficiency. Here, it is represents the country, the university, and that has to be conducted by certain authorities, recognized authorities. International, national, inter-university school.
Open championship. Open championship.
Yes, my lord. Some is open championship and some is invitational.
On invitation and open championship.
However, the same.
No, you tell us which one, on what basis yours has been. What is your certificate?
Yes, respectful submission, my lord. I don't have my brief. So brief is with my senior SMO. So even without brief, I try to submit before this honorable court. So my lord may fix the matter on 30th Monday. For the,
Heard Mr. Tititara, then counsel for the petitioner. In WPC, 464. of 2020 and Mr. Aring in WPC 320 of 2023 and Mr. N. Ratan London, Additional Advocate General for the state. You clarify which there are 36% in which what certificate on what basis this is rejected. We'll see.
That, my lord, I have already filed in my opinion.
I mean, you are filing, we don't know. We're hearing the matter. You have to show us,
Yes,
tell us.
I'll satisfy my lord.
You don't have the brief. Don't do that.
Fine, it happens.
It's not proper.
Good boy. You'll come prepared next time.
On Monday.
Hard in part. List after a week.
Good.
Not Monday. Thursday, make it Thursday.
Thursday.
My lord, our interim is there, interim.
Interim for what?
Interim has been modified, my lord.
Modified interim.
Okay. Interim order first, let's still continue.
Modified interim order.
Let me.
May I please, my lord?
Yes.
My lord, in fact, this petition was filed for shifting of the tower. However, it seems that lordship, the concerned respondent authority has the power under section 10 of Telegraph Act to place tower without even the consent. So I'll be confined to my alternate prayer, lordship.
What is your alternate prayer?
Alternate prayer is for lordship granting of adequate compensation, lordship.
Under the Telegraph Act.
No, my lord, my lord, there is an efficacious alternate remedy which exists. Give me that document. My lord, a similar matter had come up before the Guwahati High Court coordinate bench, my lord, and I'll start with that judgment. And Century Textile is a landmark judgment on that. An alternate remedy which exists for him, he can go and exercise it at the appropriate court. If he's aggrieved after the assessment is done. So, my lord, for him to pray for adequate compensation at this forum, my lord,
If my
it
learned
will be
friend,
overstepping for him because he has to first exhaust his remedy which is available to him.
lordship, the issue is, lordship, there was an assessment. This is not connected to the, of course, it is connected. However, the damage was caused by, since the tower is not yet installed, lordship, the damage was caused by the construction of substation, lordship.
My lord, para 21. If I may, my lord. In view of the discussion made above, this writ petition is therefore not entertained, reserving the liberty to the petitioner to seek the statutory remedy under subsection 3 of section 16 of the Indian Telegraph Act 1885. In the event the petitioner prefers any such application before the jurisdictional court under the provisions of the Indian Telegraph Act 1885, it is observed that the jurisdictional court shall consider the issue of limitation liberally innovations made herein above with regard to the provisions contained in section 14 of the Limitation Act. My lord, the question of limitation does not arise for them for computation, but the principle which we draw here is that there is an alternate efficacious remedy which exists, my lord, under 16(3). My lord, I will also place one landmark judgment, Century Textile. My lord, Century Textile, it's a landmark case where the whole position has been defined. My lord, the facts of this case was that agreed by the amount of compensation which was given after the joint assessment, they had come up by way of this writ for an enhanced compensation, my lord. So, my lord, the court observed that since there is an alternate remedy available, powers under 226, my lord, para 15, para 13 states the facts, my lord, of the issue, and para 15 speaks about the alternate remedy which exists.
Yes, section.
My lord, Century Textile, I have placed my lord, Century Textile will cover the reproduction of the section also. This is a landmark case, my lord, from the Supreme Court. If I may, my lord. Well, this should be 2017 5 SC. My lord, para 20. My lord, para 20, if I may. My lord. In the instant case, the aforesaid rule is not applicable in view of section 164 of the Electricity Act 2003, which reads as under 164, exercise of powers of telegraph authority in certain cases. The appropriate government may, by order in writing, for the placing of electric lines or electrical plant for the transmission of electricity or for the purpose of telephonic or communications necessary for the proper coordination of works, confer upon any public officer, licensee, or any other person engaged in the business of supplying electricity under this act, subject to such conditions and restrictions, if any, as the appropriate government may think fit to impose and to the provisions of the Indian Telegraph Act 1885, any of the powers which the Telegraph Authority possesses under the Act with respect to the placing of telegraph lines and posts for the purposes of a telegraph established or maintained by the government or to be so established or maintained. 21. It is not in dispute that in exercise of powers under the aforesaid provisions, the appropriate government has conferred the powers of Telegraph Authority, wide notification dated 24/12/2003, exercisable under Act 1885 upon the power grid. It may also be mentioned that a central transmission utility CTU is deemed licensee under the second proviso to section 14 of the Electricity Act. Power grid is a central transmission utility and is therefore a deemed licensee.
Yes, yes. Yes. Lordship, what is your prayer?
My prayer is, Lordship, for the compensation to be paid for the
Yes.
damage caused by Lordship. Here,
Therefore, section 16.
Lordship, fact is different because
Section 16, you are seeking compensation.
Lordship,
Section 16, read section 16.
yes, this section. However, Lordship, there is a slight Lordship differences. Lordship.
What do you want? You tell us.
Lordship, the reason why Flowmore was made as a party respondent, which was which later on it was they have been struck of, Lordship. They have built one power station, substation in the.
Ultimately, you are claiming compensation.
Lordship.
Then,
Lordship, that
read section 16.
Yes, Lordship.
You are entitled not under any other law.
That land was acquired by state government for establishment of, and then with regards to this.
My lord, the compensation stand also will be made clear. If I can have my lords, I can take my lord to annexure 13, page 90 of my interlocutory application. That is the notification which they have challenged in the writ as impugned notice. Now, my lord, that notice reads, it is sent by the competent authority. That notice tells them, whereas the concerned authorities have approached you for assessment and providing of rightful compensation, but you have not cooperated and resisted adamantly, obstructing the lawful developmental work. My lord, for payment of compensation, we have approached them repeatedly for the last 2 years, but they are not coming to stand with the assessment. Now, my lord, once the assessment is done, if they are aggrieved by the quantum which has been arrived at, then section 16 provides them the remedy of going for an enhancement or if they are not satisfied with the computation of compensation. But my lord, they cannot say that we have not paid them or we are not paying them the compensation, because despite us repeatedly telling them to please come forward for assessment, they are not coming forward.
Lordship may come to page 36, Lordship.
What do you want? Tell us.
Lordship, this is with regards to the
You
damage.
want the compensation to be paid under 2013 Act.
Lordship, I'm not on that, Lordship. Lordship, basically this particular there was a verification report also while constructing that substation. There was while constructing the substation, they have damaged the area. This they have been repeatedly.
Whatever you are entitled under the law, they are ready to pay. You have the assessment. Talk to them.
Lordship, in that.
What's the requirement of directing us when they are ready to pay?
Lordship.
Yes.
In that case, Lordship,
Page 175.
I may be allowed to approach the appropriate.
By the power grid matter. The petitioner assessment has not been done because he has not allowed the assessment to be done. Now, if assessment if he is admitting to that, the assessment may be done, adequate compensation may be given. That adequacy in education will come after the assessment is done, and the alternate remedy under section 16 will come thereafter. First of all, the assessment has to be done, and then he has to be paid. Page 175.
Yes. What is to be done?
That assessment, the petitioner may be directed to comply, cooperate with the assessment, and then yet the assessment be done so that compensation can be paid. But at least not to stop the work, matters. Not to obstruct the construction.
Well, these are the area. This is the only source of livelihood for the petitioner. That is why nearby, Lordship, in the arrow mark, you will see the substation, Lordship. Since this has been constructed in the year, I started construction in the year 2023, Lordship. Now they are asking the petitioner to cooperate with the assessment with of the post, Lordship, tower 132 kV tower.
What do you want now?
Lordship,
assessment will be done.
My lord, he should come forward for assessment. And
adequate compensation,
Direct
Lordship.
them to deviate from your lane.
Lordship. That is
the, rejected.
Yes,
Number
Lordship.
two.
That comes.
Yes, you will be entitled under the law any compensation.
Lordship.
So better you withdraw and will permit you to approach the authorities.
Lordship. In fact, regarding this installation of tower, they have been approaching. However, I was aggrieved by the damage caused by the
whatever. Yes, no, damage, I mean, that we cannot direct how damage, how much damage, what amount. They are ready to have the compensation assets. You have
Lordship may direct the authorities to reassess the damage caused by the while constructing.
My lord, the substation and the transmission are two separate systems under two separate contracts. Now, my friend here is trying to club both of them.
No,
There are
no,
two separate. Let me complete.
I'm trying to
There are
separate it.
separate modes of calculation and computation of assessment. This writ petition has been filed specifically in respect of the transmission line, for which they have also received a status quo order. Ex parte, but they have received. Now, my lord, with regards to the transmission line, how it works, my lord, is that when we are about to my lord, so they can come forward for, we will do the assessment. Whatever is the
Para
damage, we
3,
will-
my Lord Senior, he has pointed out the differences. Lordship, I'm on prayer number 3, Lordship. For the compensation to the petitioner for the damages in WRC field at Kamke. So this damage was already caused by construction of substation, and there to the executing agency is the power grid, Lordship. So that grievances, they have not, Lordship, heard the grievances of the petitioner, Lordship. That this is another aspect. Another aspect is, as he has rightly pointed out, that 130 is tower line, Lordship. So I'm on prayer number 3, Lordship. So if the power grid can, if they can tell whom to approach, because this particular damage was already done. That is the reason why Flowmore was made as a party.
My lord, we will be approaching them. We have earlier also approached.
See, prayer number 3.
My
He
lord.
said they are seeking compensation for damages done to their field.
My lord, the damages will be adequately compensated once the assessment is done. My lord, the assessment will be an ongoing process because, my lord, we will make inroads to come there. When the tower erection, so they will have, he is there.
Then we'll direct you to make assessment and pay the compensation.
My lord, that is as per law, that we are agreeing, we ourselves are saying. If my lord sees last page of my counter affidavit, I am the one writing to the deputy commissioner that he is not allowing me to do assessment.
Lordship, that is with regards to installation of tower. With regards to installation of tower, there is a difference. One damage already caused because of construction of.
That's what I'm saying. Look at the prayer number 3.
My lord, we will pay adequate compensation, whatever comes out as per the assessment on the prescribed.
And Mr. A. Tatak, learned counsel for the petitioner, and Mr. Your
and
Ratan, learned additional advocate general for respondent number 1, 2, and 1 and 2, and Mr.
N. Khera, my lord.
N. Khera for respondent number 4.
My lord, now I become 3 because 3 has been struck off.
Huh?
3 was not struck off. Okay, 4 yeah.
You are 4 only.
My lord.
Power Grid Corporation of India. PGI, what is this?
PGCIL.
PGCIL. Respondent number 4. By filing this writ petition, how many petitioners? One.
One, Lord.
Petitioner essentially prayed for a direction to the respondent number 4, respondent number 3, respondents, respondent authorities to pay adequate compensation to for the damages caused to his WRC field at Kamki village, West Siang district, Arunachal Pradesh, on account of what? Construction of
substation.
It's a transmission.
Construction of
Transmission system includes everything.
transmission system from Alo to
No, Lordship, it's power substation. That is the reason why I have given that.
what he's saying is the construction of transmission and everything. Is it? Am I correct? Construction of transmission system. It includes everything. Transmission system. What is the project?
132 kV, Alo Khamba.
Construction of 132 kV line transmission system.
Alo Khamba.
What do we call says?
132 kV, Alo Khamba TL. The
TL.
system's name is 132 kV, Alo means the transmission system starts from Alo till.
What do we call it? Construction of transmission system of 132 kV. Alo
Dash Khamba.
Alo to Kamba
Khamba TL.
TL. What is TL?
That includes the whole system. From origin to
Transmission line. Yes, right. Huh? List of the petitioner is a resident of Kamki village. No, the hails from Kamki village, who is having a WRC field.
Lordship.
At where?
At Kamki, Lordship.
At Kamki. List of according to petitioner, for construction of 132 kV transmission line between Alo to Kamba through the Power Grid Corporation of India Limited, which passes through the WRC field of the petitioner, has caused severe damage to the land of the petitioner. List of being agreed, the petitioner has approached the various authorities for shifting of the said transmission line and for adequate compensation, appropriate compensation for the damage caused to the land of the petition. List of, however, as no response. However, assume that the authorities has failed to address the grievance of the petitioner. List of Mr. So-and-so, what is your role? State.
We are implementing this. Just a background of the project. This is a project which has been funded by Government of India for strengthening of the
Mr. Learned Addition Advocate General submits that since the construction of 132 kV transmission line is in the interest of public, and it involves technicalities, there could not be it would not be possible for shifting the construction from the original plan. However, the petitioner may be entitled to compensation as per the law under the Electricity and Telegraph Act, or what do we call it?
the state notification of 2019. As per the applicable,
As per the applicable law, including the Telegraph Act and the guidelines issued by the
state of
guidelines issued by the state of Arunachal Pradesh. Mr. N. Kera fairly submits that the petitioner would be entitled for adequate compensation under the relevant acts and rules, guidelines, including the Telegraph Act for which the respondent PGI Power Grid Corporation of India is ready to compensate in accordance as per the applicable acts and rules. He submits that despite despite best effort of the PGCIL, the petitioner has refused to cooperate with the authorities for assessment of the compensation of the land. Therefore, the petitioner may be directed to cooperate with the authorities for appropriate assessment for payment of appropriate compensation under the law. Please. Having considered the submissions of learned counsel for the parties, and as agreed to by this writ petition is disposed of, shorn of unnecessary discussions of the facts and issue, with a direction to the parties to assess the compensation as per the applicable law, including the Telegraph Act. Please stop.
This notification is the government of Arunachal Pradesh to take care of the board process.
It's okay.
Notification dated 29th August 2009.
No, accordingly, the respondent authorities are directed to properly assess the properly assess the properly assess to make proper assessment, directed to make assessment for payment of compensation to the petitioner as per as per the law, including the Telegraph Act and the guidelines. What is the name of the guidelines?
RSE 2425-2013, partly dated Itanagar 29th of August 2019.
What is the name of the guidelines?
It doesn't come in the name, it is the notification.
As per the notification,
29th of August 2019.
29/08/2019, issued by the Department of Power, Government of Arunachal Pradesh. Listen, it is it is also provided that the petitioner shall cooperate with the respondent authorities for appropriate assessment as directed herein. Please stop. On such assessment, the respondent authorities shall pay the compensation to the petitioner. Please stop. The whole exercise, the exercise as directed herein shall be done within a period of 2 months from today. 2 months from today, right?
But my lord, they may not create any hindrance and obstruction.
Obviously, they'll not.
Lordship,
It is provided that
Lordship, small prayer, Lordship.
it's provided, it is further provided that the petitioner shall not create any hindrance to the construction of so and so, huh?
Lordship, if we go by 2019, Lordship, they will not consider the damage already caused to the WRCP. They will use it for as a user only, Lordship. They will pay compensation for as a user.
The earlier damage they have already assessed. It is as per this
Lordship, that is why I was seeking for assessment of earlier damage caused to the petitioners.
Whatever damage, whatever damage we don't know, but then whatever you are entitled under the law, you will be.
Lordship, my small deeply obliged.
My lord, the IA also be.
We'll just in that case, including the damages already caused.
Without saying it is part of our
No,
damage.
Lordship, if that is
part
mentioned.
of our damage, we
No, if it is a problem, if it's not a problem, then we include that.
100%. My lord, 100%.
Make assessment,
Absolutely.
including the damages already caused
My
to
lord.
the over the land of the on the land of the petitioner. That will end.
Lordship.
My lord.
Otherwise, you'll
My
not,
lord, we will.
you will not be happy.
No, no.
Yes,
deeply obliged.
In view of this, the IA.
IA and all this, huh? Dispose.
Number 12, obliged.
May I please, ma'am?
Yes.
Well, this is this two bail application arising out of the same affair. As on today, my lord, more than 1 month, 1 year, 6 months, they have been in the custody, my lord. So far, my lord, there is a trial is going on, my lord. If we see the entire case, my lord, including the deposition, I have annexed the deposition of the victims also, my lord. This is basically the case, my lord. It is not something where, my lord, forcefully.
Yes.
And this section 35 of the
May I, my lord?
Yes, affidavit.
My lord,
On the prayer,
my lord, I'm very allowed to some more time to file an. I'm
affidavit of what?
reply. I'm from private respondent, my lord.
Number 4.
Yes, yes, my
Okay,
lord.
heard Mr. So-and-so for petitioner, land counsel for the petitioner. You have filed.
Yes, we have.
Mr. N. Long, Lana Senior Government submits that he has filed affidavit on behalf of the state respondent. On the prayer of Mr. So-and-so.
Esther.
Learned counsel for respond number 4. Press 4 and is granted for the 3 weeks time.
Obliged.
Yes, Your Lordship, I'm appearing on behalf of the petitioners. Here, the state was supposed to file the affidavit.
Yes, state.
Yeah, but I need some more time, my lord.
Heard Mr.
Manta.
C.W. Manto, learned counsel for the petition. On the prayer of, no, list the matter after 3 weeks. So as to enable Mr. MS. Learned state counsel to file affidavit.
Interim is there, Your Honor. There is
Interim.
an interim. Yes.
Interim order passed.
Obliged.
Yes.
May I answer? Lordship, I need some more time to file my rejoinder.
How many times?
Lordship, 2 weeks.
How many times you have to make an ask for time to file a reply? Reply.
Yes, Lordship, for rejoinder.
So and so land council is granted further 3 weeks time to file affidavit in reply as a last chance. You've taken so many times.
Wait.
Yeah.
Otherwise, within the private respondent number 5, was granted time till 12th of this month to file our affidavit. Our affidavit is ready, but the deponent matter, because of not getting leave when it could not come, I can definitely file it by Wednesday, matter. Since you, I will do.
No, his lordship, last order was to,
Up to 12.
Yes.
no, hear the matter on its own merit if they don't file.
Today.
Yes, lordship.
By
Anyways,
Wednesday, I can definitely file. Monday, I will be there at Teju, so I can take a sign there.
What is the matter?
selection, lordship,
Okay.
sports quota.
Third MS and London concept for this. Although this court has granted the respondent number 5 to file granted respondent 5 for filing affidavit in opposition, fixing the date today for disposal of the petition. Come. Mr. Deepang Land Council for the respondent submits that all the affidavit is ready. No, on the ground, on the prayer of Mr. Deepang. Two days time.
By Monday, I can get the signature and I will pay you. By Wednesday, I will.
Further 2 days, further a week's time is granted
Definitely.
as a final chance, a final opportunity to file the affidavit. As considering that why you are not able to get the signature?
No, because she has not been able to get leave. Our controlling officer.
Considering that the respondent number 5 is unable to sign, I mean, unable to sign the affidavit, swear the affidavit because of the because of non-grant of leave from his service, from her or she or her, from her service.
Actually, the controlling
Who is
officer is not there.
Who is serving at where?
Teju.
Okay, final opportunity. List,
Definitely
list
final.
after a week. 1 week final opportunity.
Lordship. I may also need to file reply, who knows, depending on.
Yes. Okay, then we'll list after.
It will automatically, if it's after 1 week, it will automatically come after vacation.
This matter, my lord, I was appointed amicus curiae in the year 2017. That was because the honorable court felt that the learned counsel appearing for the petition at that point of time was not being able to articulate the facts properly. In the meantime, it was dismissed for default in 2019. Now, my lord, I have seen the order. I believe Mr. Rava and all are appearing in this case. They have had it restored. names are not shown maybe big, but that's why they are getting.
What is to be done?
I will inform Mr. Mao, my lord, I think his name is also there.
This has been restored.
Yes.
Okay. It is noticed that Mr. Deepangi Learned Counsel was appointed as amicus in this matter. Mr. The writ petition was also dismissed. For default. However, same is restored. Same has been restored to file. Mr. The petitioners now appears to be represented by Mr. S.R. Raba, Learned Counsel for petition in view of above. However, the name of the Learned Counsel representing the petitioner is not reflected in the host list. In view of above, let this matter be listed after 2 weeks. Registry to reflect the name of the Learned Counsel for the petitioners in the host list.
Public.